Today, I want to talk about a trend across federal agencies, a push to roll back regulations that the Trump administration believes are slowing down innovation in health technology. Whether you're building AI tools, wellness apps, or clinical software, the regulatory environment is shifting, and it's worth taking a look at what's changing and what isn't. One of the clearest examples is the ONC's recently proposed HTI-5 rule. It's a significant move toward deregulation, and the highlights include reducing certification requirements for health IT developers, cutting 34 of the 60 existing criteria. That includes several clinical quality measures and some privacy and security requirements. Eliminating model cards for AI systems, which means developers of clinical decision support tools would no longer need to disclose details about data sources, algorithmic logic, or performance characteristics. The stated goal is to reduce burden and accelerate innovation, but the practical effect is less transparency and fewer guardrails around how AI-driven tools are built and evaluated. This isn't happening in isolation. Over the past year, multiple agencies have signaled an interest in loosening oversight of AI to encourage faster development and deployment. Overall, the federal government wants to create more room for experimentation. But that doesn't mean risk disappears. If anything, the potential for AI-related liability, especially around bias, transparency, and clinical safety, becomes even more important for companies to manage internally. On the device side, the FDA has also relaxed its posture through recent guidance. If you're building an app or wearable focused on things like sleep, stress, or general well-being, you may fall into the general wellness category, meaning no pre-market review and no medical device classification. For many consumer-facing developers, this is helpful. It lowers uncertainty and may encourage more innovation in the wellness space. But again, it's not a free-for-all. The moment your product makes a medical claim or crosses into diagnostic or therapeutic territory, the FDA's full framework comes back into play. So, how significant is all of this? It depends on where you sit. For wellness app developers, this is meaningful. You may avoid FDA oversight entirely. For AI developers, the removal of model cards reduces administrative burden, but increases the importance of internal governance. For enterprise health IT vendors, certification is still required, just lighter. But is this groundbreaking deregulation? Probably not. Core laws like HIPAA, the anti-kickback statute, and state privacy frameworks remain unchanged. And if you're selling into Europe, the EU AI Act is waiting with a very different and much stricter set of obligations. Here are a few practical takeaways. Don't relax your internal controls. Transparency, documentation, and bias mitigation still matter, maybe more than ever. Build for the strictest market you serve. If you operate in both the US and EU, the EU AI Act will likely drive your compliance posture. Monitor the regulatory landscape. These changes are real, but they're incremental. The pendulum will continue to swing back and forth between regulation to deregulation, and agencies and administrations can also shift direction quickly. And that concludes our Free Flow update. Thank you for joining us today. For more information, please visit our website at orensteinlegal.com and navigate to the podcast page. Remember to subscribe or follow Free Flow on Spotify, Apple Podcasts, and YouTube so you never miss an episode or update. This podcast is for informational purposes only, is not legal advice, and does not create an attorney-client relationship. Thank you for listening.